It is 14939, that is correct.
All those in favor of adding amendment 014939 to House Bill 1971, please say aye.
Aye.
All those against say no. All right, Senate, your bill. Sir, you're recognized.
Very good, members. What this bill does, this brings the law back to the way it was prior to 2018. The General Assembly changed the law and inadvertently allowed for folks to be able to sue the state and other entities for policy disagreements and not substantive disagreements on the law that without any damages. Best way I can put it is, as I said in subcommittee, the best example I can give is if a person is hit by a truck traveling down an interstate and breaks every bone in their body, they have damages. If you're driving down the road and a big truck, a big wheeler, big rig drives by you and you feel the wind off, it doesn't hit you, you can't sue that person because you don't have damages. So what this is doing, this is restoring the law to the way it was prior to 2018. So members, with that explanation, I'll be ready to stand for any questions. And I believe we have some testimonies.
Yes, thank you, Chairman. I'd like to call up, we've got Richard Archie, John Gentry, Matt Rice with the Attorney General's office, and then also Cody Brandon with the Attorney General's office. So if you're here, please come forward. Okay. All right, members, we're going to go out of session to hear this testimony. Mr. Gentry, would you like to go first? You've got 2 minutes. Over here.
Is that me?
Yes, John Gentry.
This on?
Yes, sir.
So my name's John Gentry. Members of the committee, the Constitution is supposed to protect people before they're harmed by government, not after. And this bill reverses that principle. And what Chairman Farmer is talking about, harm, that's called the standing doctrine that the courts use. And the standing doctrine is not law. The standing doctrine is a judge-developed legal doctrine. And so when the legislature says, well, we're gonna let judges go ahead and make the law, that you have to suffer harm before you can bring a lawsuit. And I think that's wrong with the standing doctrine. It's used very often by the courts to wrongfully dismiss cases. Under the Tennessee Constitution, Article 1, Section 1, the people have a right to reform government. Is a government who has enacted unconstitutional law in need of reform? Of course it is. And does Article 1, Section 1 say there must be harm? It does not. Article 1, Section 2, the doctrine of non-resistance is absurd. It is absurd of citizens to not resist arbitrary abuse of power with government enacting law that is unconstitutional. Under Article 1, Section 17, suits may be brought against the state. It is a constitutional right under the Constitution of this state. Article 1, Section 23, citizens have a right to apply to those invested with the powers of government for proper purpose by address or remonstrance. Does Section 23 say we have to suffer harm before we can apply to government? It does not. Does Section 23 say we can apply to those invested with the powers of government? Yes. Is a court invested with the powers of government? Yes, it is. So this law itself is oppressive of constitutional rights.
Your 2 minutes are up, sir. Your 2 minutes are up, sir. Thank you.
If anybody has any questions, I would be happy. Thank you.
Mr. Rice. Stay there.
Thank you, Vice Chairman. I guess a couple points in response to some of the remarks that we just heard.
Mr. Rice, would you care to introduce yourself?
Oh, I'm so sorry.
That's right.
My name is Matt Rice. I'm with the Attorney General's office. I'm the Solicitor General of Tennessee. Thank you all for having me. Just a couple of points of clarification with respect to my friend's comments on the other side. My friend seems to be taking issue with the standing doctrine. The standing doctrine stems from the Tennessee Constitution. The legislation can't change the Tennessee Constitution, so this bill has absolutely nothing to do with standing. Standing stems from the Constitution, not from statute. So while My friend may take issue with the Tennessee Constitution's requirements. That is not before this body at this point. Another clarification, it is absolutely false that under this bill, people would not be able to vindicate their constitutional rights and bring a pre-enforcement challenge. I think a little bit of context is helpful for where this statute kind of fits in. This statute was not enacted until 2018. A number, as this body knows, a number of constitutional challenges were raised before this statute existed in that pre-2018 regime. What this statute does is return the law to that 2018 regime and essentially prevent what are effectively policy disputes with the laws passed by this body. It would require, under the Supreme Court's Colonial Pipeline decision, it would require a person to actually have their rights implicated by some governmental actor, rather than just kind of picking out a law in the books that they don't like. And so I do think there's a lot of confusion with respect to what this law is doing. It is essentially ensuring that the parties who bring suit actually have their rights implicated, rather than just have a policy disagreement. And I think that the amendment to the law makes that absolutely clear and clarifies that this section does not limit any other cause of action or waiver of sovereign immunity to vindicate rights under the Tennessee Constitution or the United States Constitution. I think it's extremely plain that that this is in no way putting the government above reproach.
Thank you, sir, I appreciate that. Representative Keesling, for you wanting to ask the question? Well, you're recognized,
Yes,
sir.
thank you, Madam Chair. Potentially, I got one quick question here now. Potentially, does this shift power away from our local governments? Could any way, shape, form, or fashion? Could it? Just yes or no?
No.
No, it cannot. Thank you very much. Thank you, Madam Chair.
Representative Bolzo, you're recognized.
Thank you, Madam Chair, and thank you, General Rice, for being here. And first, let me thank you for the tremendous service that you provide every day to our state. We are so lucky to have you in that role. I have two questions for you. The first dealing with sovereign immunity, and the second dealing with the term affected person. First, dealing with sovereign immunity, is it correct that our state Supreme Court has determined that 1-3-121 has affected a waiver of sovereign immunity by the state and its political subdivisions, and that this bill, HB 1971, if passed, will return to the state immunity that was previously waived?
I think it will return it, but not to the extent that Colonial Pipeline still exists. And so Colonial Pipeline is essentially the state equivalent to, in the federal courts, what is the Ex parte Young doctrine. Now, this went beyond Colonial Pipeline, 1-3-121 did, and I think by the alteration to the underlying statute here would return us to the Colonial Pipeline framework. And I think that has essentially two differences from the waiver of sovereign immunity that we see here. The first difference is under 1-3-121, lower courts have held that the state writ large can be held or can be brought in as a defendant. Now, typically you have to sue the specific state official that is actually enforcing the law. Now courts are saying, well, this says you can sue the state. And the effect of that is in discovery, we are getting essentially buried with requests for documents from all state actors. So instead of, for example, a district attorney, you could sue a district attorney in your district to not enforce this statute against you. And instead of having to find documents from that district attorney, we're having to search for documents throughout all types of different state officials. And I can give you an example. In a recent litigation regarding the abortion medical necessity exception, we were asked to turn over the emails of this body and the communications of this body because they wanted to know what was going on behind the scenes and why this abortion bill was passed. We fortunately lost at the trial court. We got interlocutory appeal granted, and they withdrew that request. But under this, I think this body should be prepared to have every law that's passed, they're gonna challenge the underlying reason for why that law is passed, and they're going to come after the documents of this body. The second difference between 13121 and the Colonial Pipeline is that it requires you, as I mentioned, to sue the governmental actor that is enforcing the law. You can't just sue the state writ large. You have to actually have some actor that is attempting, or that there's a credible threat. That's all that's required, is a credible threat of enforcement, and you can bring suit under the Colonial Pipeline Doctrine. And it's been done for decades. I mean, it was done until 2018. We have scores of constitutional cases in the Tennessee Reporter prior to the enactment of this law.
Understood, but as the statute currently stands, an affected person could bring an action against the state at large. But if we adopt HB 1971, that will no longer be true. Is that correct?
I don't agree with that. I guess it depends on what you mean by an affected person, but I think affected person could bring a suit under Colonial Pipeline against the specific state official that is charged with enforcing the law.
Yes, but Colonial Pipeline is the state equivalent to the federal ex parte young, in which case you can bring an action against a state official prospectively to enjoin the enforcement of an unconstitutional statute, but you cannot bring a case directly against the state under Colonial Pipeline. Is that correct?
That's correct. Under Colonial Pipeline, you have to sue the actual state official that is charged with enforcing the law. You don't just get to name the state writ large.
And then the second question I had for you, General, was the issue about affected person. Obviously, 1-3-121 provides this cause of action to what's defined as an affected person, which is an identical term to what we see in the Declaratory Judgment Act that's been obviously in effect now for decades. So isn't it the case that having the requirement that an affected person bring the cause of action deals with this concept that anyone out of the blue can just file a case against the state under 1-3-121? Because the person has to show that he has rights or status or legal relations that are affected by the statute at issue.
In theory, yes. In practice, it hasn't been interpreted that way. But in theory, yes.
Thank you, Mr. Chairman. Thank you, General.
Representative Johnson, you're recognized.
Thank you, Madam Chair. So to Mr. Gentry, in the description of this bill right underneath, it says, as introduced, removes the right of a cause of action for any affected person who seeks declaratory and injunctive relief in any action brought regarding the legality or constitutionality of a state governmental action. When I see something that says removes the right to a cause of action, I find that concerning. Is that something that concerns you with this bill as well?
Absolutely, Representative Johnson, you should be concerned. So seeking declaratory judgment is asking a court to declare a statute as unconstitutional. And so they're saying the citizens can't challenge that. And that goes against the principle that we have a right to reform government and we have a right to apply to government. It doesn't say that we have to suffer harm. And the gentleman for the state here has said that the Tennessee Constitution includes the standing doctrine. I actually authored a book explaining the Tennessee Constitution, focused on the Declaration of Rights, but in other parts of it, I have not seen that. And I would like to see how the Constitution is interpreted to say that the standing doctrine is part of our Constitution, because I don't think that it is. But it should raise serious concerns that we can't bring a cause of action. You know, already, and I say it with hesitation, but quite frankly, these houses make a mockery of the right of citizens to petition the legislature. We should be able to come to the legislative houses and address the legislative body and say, we think this law is unconstitutional. And so that constitutional right that we have that is fundamental to a government Republican in character, we don't have that right to petition the legislature and address the body and complain that something is unconstitutional. And so now it seems that we want to take away the opportunity to even go to the courts. And so now we have to wait until somebody suffers, until somebody is harmed, that they get prosecuted. Maybe they have to place bail before they can challenge it. And then when they do challenge the constitutionality constitutionality of the law in court, I believe it is Tennessee Code, TCA 2914-107B, that if you challenge a statute as unconstitutional, you have to notice the Office of Attorney General. And if you fail to notice the AG, the court says, well, you didn't follow the rule, you didn't notice the Attorney General, and so this issue is moot. We're not even going to address the question as to the constitution of this statute that you may be prosecuted under or may have suffered harm for. And that is not an appealable issue. So if you don't notice the AG when you challenge the constitution of a statute, you are done. That issue will not be addressed at the appellate level or at the trial court level. And so there are procedural shields in addition to the fact that standing is not law. It's a legal doctrine. And that we have a right to reform government, and we have a right to apply to government, including the courts. And so this bill itself, in my strong opinion, is in violation of our state constitution because it oppresses the right to apply to those invested with the powers of government, and it oppresses the right to reform government. And it oppresses the right to bring suits against the state in Section 17. Thank you for that question, Representative Johnson.
Representative Johnson, any follow-up?
Oh, no, I'm good, thank you.
All right, thank you. Representative Scarborough, you're recognized.
Move to go back in session.
Second.
All right, members, we'll go back in session. And so I have Representative Travis, you're recognized. Thank you very much, gentlemen, both of y'all for being here present. Thank you very much.
Thank you, Madam Chair. I'll call previous question.
All right, members, we're voting on, Madam, can you open the board for a previous question? We're gonna need to vote on that, please. All those in favor of previous question, vote aye. Those opposed, vote no. Anybody want to change their vote? Madam Clerk, can you please call the vote?
Madam Chair, you have 13 ayes, 7 noes, and 0 present not voting.
All right, previous question fails. Representative Todd, you recognized.
Thank you, Madam Chair, and I appreciate the testimony we had. I appreciate a lot of the conversation we've had back and forth with a lot of good folks in this argument. We've got some very strong conservatives on one side of this issue, and we've got strong conservatives on the other side of this issue that I trust. So this is really putting me in a tough spot to try to dig into details for something that is very difficult for me to understand since I'm not in that world every day like some of our folks. But I have learned that as the testimony brought out a minute ago, the interpretation is the issue. The law was passed in 2018 after 222 years of this state existing and not having any problem whatsoever in this realm. That's what's baffling to me, and no one has been able to come to me with a legitimate answer of why that was a problem. And they weren't bringing this issue of a constitutionality to this General Assembly to fix. The issue that was brought for some licensing agencies in the state has now been judge developed, as the gentleman used a while ago. The judges have developed this interpretation around government actions, what that means, and around affected persons. And that's really the crux of this. And this bill, I believe, narrows that back down to what it should be, what it was for 222 years when nobody had a problem. And I think that's what we need to go back to, and I appreciate all folks contributing to this argument, bringing us information and sharing with us as members, and bringing their issues. You have literally brought your issues to the General Assembly, and we are dealing with those. That is what the Constitution says, that you may petition your legislators, and you have done that. And I appreciate the process. So thank you for everybody's been involved in this.
Any follow-up? All right, thank you. All right, Representative Johnson, you're recognized.
Thank you, Madam Chair. This is an odd one as well as my colleague just spoke about. I've heard from all sides of the aisle, but I can tell you that I got a lot of emails on this issue And some people will tell you, I'm a Republican, or I'm a Democrat, or I'm an independent. But I don't think I got a single person that wanted a yes vote on this bill. They were all very concerned about it, and regardless of the party, everyone who emailed me on this legislation were against it. And so I'm gonna have to vote with my constituents on this bill. Thank you.
Representative Bolso, you're recognized.
Thank you, Madam Chair. Members, let me try to be somewhat helpful in distilling what I see the issue to be, because I've been involved to this point in 3 litigated matters that involve this very statute, 1-3-121, 2 of which are still pending, one against the local government, one against a state official in her official capacity. And what Chairman Todd says is correct, that for 222 years, we did not have this statute, 1-3-121, but nevertheless, there were means by which citizens could raise and challenge the constitutionality of statutes. You heard from General Rice that prior to 2018 was done pursuant to this colonial pipeline case, which is a state equivalent of a federal case called Ex parte Young, which allows you to sue a state official to enjoin prospectively the enforcement of a statute that is alleged to be unconstitutional. And the reason you could do that was because there's no sovereign immunity that attaches to a public official enforcing an unconstitutional law. The law is very clear about that. But what happened in 2018 is that this body passed this statute, 1-3-121, and it said regardless of any other law, a cause of action exists in favor of an affected person to challenge the legality or constitutionality of any governmental action, which includes a statute. And our Tennessee Supreme Court in 2022 interpreted 1-3-121 to be a waiver, an intentional and clear waiver of sovereign immunity. So that what happens in court now is that when a party has to sue the state for a political subdivision, you bring the action pursuant to 1-3-121 because it takes away this defense of sovereign immunity, which is one of the principal defenses that the state would raise in defense of an action regarding legality or constitutionality. And in the cases that I've been involved with, I mean, we've been successful every time in defeating arguments about standing in sovereign immunity because we had 1-3-121. So if we adopt HB 1971 and we take it away, will citizens still be able to sue the government over legality and constitutionality of statutes? Yes. Will it be more difficult? Yes, it will be. It'll be back to the standards that we had before 2018. So in summary, if you're someone who believes that the General Assembly went too far in waiving sovereign immunity in 2018, and you want to make it more difficult for citizens to sue the state government, not the local governments, they're exempted out of this recapture waiver of sovereign immunity. But if you want to make it more difficult for citizens to sue the government, then you probably want to vote in favor of this bill. But if you're someone who does not want to give back that sovereign immunity, if you're someone who wants the people of Tennessee to retain the rights that they obtained when this body adopted the statute in 2018, then you're going to want to vote against this. But this is clearly something under our Constitution, Article 1, Section 17, that rests with this body. It's the General Assembly under the Constitution that has the authority to waive sovereign immunity if and when it wants to. This body chose to do that in 2018. It can take it back in 2026 if it wants to. The question is, do you want to do it? Do you want to do that? Do you want to make it more difficult for citizens to sue the state government? Or do you want to keep the rights in place? That, to me, ladies and gentlemen, is what it comes down to. And for my part, I like the statute as it is right now. I think it's difficult for me to take rights away from Tennesseans once we've granted those rights. And we definitely granted those rights in 2018 when we adopted 1-3-121. Thank you, Madam Chair.
Thank you. Sponsor, you're recognized.
Thank you, Madam Chair, as I was listening to Chairman Bolso, who I have a tremendous amount of respect for, I understand that if we made it much easier to sue the state of Tennessee in 2018 because we allowed people to come and bring lawsuits based on policy and not legal arguments, based on policy, not actual harm. We're the only state in this country that allows for folks to bring lawsuits against the state based on policy and not actual harm. So I thought it was important to make that point, that right now, if you just disagree with what we do here as a body, you can file suit. You don't have to show any sort of harm, just like you do in any other cause of action that we have in tort. I mean, you have to have harm to be able to bring a lawsuit, have standing to bring a lawsuit. And right now, if you just disagree with what has been done here, you can bring a lawsuit. And that's not how we should operate. You should have to show and prove your cause of action before you bring it. So I just wanted members to know that. Thank you.
Leader Langford, you're recognized.
Thank you, Madam Chairlady, and to follow up on the chairman's comments there, I mean, we were both here and voted for that bill, and I remember when it came through the legislature, it was intended to open up a small crack in the law to allow for some nuanced positions to be challenged in court. It was not meant to blow an entire hole in the side of the state's process on how it is sued. And so now every frivolous lawsuit that anybody can dream up is being filed against the state with millions of dollars in discovery over policy discussions that happen right here in this committee and should be happening in the legislative branch. The courts have extended this well beyond anything the legislature intended. And I say that as someone who, again, voted in favor of the original bill. For 222 years, as my friend the chairman has mentioned, you could sue the state of Tennessee. You could sue it in the intervening time from 18 till now, and you'll be able to sue it afterwards. And if you have a meritorious claim, it will be taken up. Will it look a little different? Absolutely. Will there be a pathway there that talented lawyers can still take before, like my friend from Williamson County will be able to? He's got multiple lawsuits pending now, and I'm sure many more that are being cooked up at this moment. And that's perfectly fine. But the courts have taken this way beyond anything the legislature ever intended, and I don't approve of that. I respect the judicial branch. I wish they would respect more the words that were on the page when we passed this, because they've interpreted this well beyond where we intended for this to go. And so no other state's done this for a reason, and a very wise friend of mine says that if you're the only state doing something, you are either leading the pack and others will start emulating you, or you've made a terrible mistake if nobody else does, because you probably have passed something that doesn't work very well for the people of the state. And the last thing I'll say on this, the millions of dollars that are being spent on litigation on this are being paid for by the citizens of this state. That's who's paying for the discovery. That's who's paying for the defense of the laws that we pass here. And at both sides of the aisle have brought that up on many different occasions. Why should we make it so easy to bring a frivolous lawsuit that can easily be taken up through amendments in the law and be debated in this chamber, and make it so easy to sue the state of Tennessee over a policy difference that we're costing the taxpayer millions of dollars? And again, not over legal issues, but over policy debates that should happen here in this body. So I certainly support the bill. I think we are arguing about some very fine distinctions in the law, and I enjoyed the back and forth between two fine lawyers that I respect both of a while ago. It's fun to watch y'all argue with each other, but we're grinding this down into very, very fine grains of sand on the differences here. I just want to reel back a little bit of the hole we blew in the side of the legal framework in our state, so that every single citizen can still sue, just like they could before, on constitutional issues, but they can't bring frivolous lawsuits just to dive into the work of the legislature, which should be done here instead of in a courtroom. Those are just my thoughts on it.
Representative Travis, you're recognized.
Thank you, Madam Chairman. I move the previous question.
Second.
Any objections to the call of question? All right, Madam Clerk, open the board. We're going to vote on House Bill 1971 as amended, moving forward to calendar and rules. Anyone wish to change their vote? Madam Clerk? Count the vote, please.
Madam Chair, you have 11 ayes, 9 noes, and 0 present not voting.
All right, we have House Bill 1971.